In three, two, one. Yes. Okay. Ladies and gentlemen, we are here with the first legal episode for Open Floor with Nishank. Last time we had the vice chairperson of the panel of Rajya Sabha sort of step up to the show, but today I have someone who's a very special guest. And let's do the formal introductions as we always do. Anchit Oswal sir is a partner in the dispute resolution practice group in the NCR office for Khaitan. Anchit sir has rich and diverse experience in advising and representing clients across various sectors and industries on issues concerning various laws before multiple forums. Today I'm not going to list out every transaction that you've worked on, sir, because that would take a separate show in itself. But we'll talk about some of the representative matters in sir's introduction for sort of, giving a brief. And on a personal note, I think I've seen sir do a lot of sessions, interact with a lot of students across India, and I'm personally very excited to have someone from the dispute resolution space. Anjit sir has advised clients in relation to investigations by agencies like Serious Fraud Investigations Office, Central Bureau of Investigation, Enforcement Directorate on matters concerning allegations of bribery, money laundering, and corporate fraud and various other offenses. Sir is also sort of in his area of expertise, advised and represented clients like a leading bank of UAE on enforcement of worldwide freezing order in India, National Payments Corporation of India's an issue concerning privacy, data localization, data sharing, information technology, etc. before the Supreme Court and the High Court of Delhi. Toyo Engineering Japan on challenge to the International Arbitration Award before the Delhi High Court. Sir, I would personally feel is sort of a wonderful expert on arbitration, and that is something that so many law students also sort of look forward to. So I think, sir, that is something that we'll sort of delve into the depths of in today's show. He's also sort of represented and been a part of deals including the Israel Military Industries Limited on disputes with the government of India over investments in the Indian defense sector, Uber on advisory and representation before the Delhi High Court, Molson Coors India on a dispute with state electricity utility on illegal disconnection of electricity, the OCS Group, the British Telecom, the Puma, Vistra ITCL. Sir, like I said, it'll take a separate show altogether because the amount of transactions, the amount of sort of deals you've been part of is incredible. And thank you so much for joining the show today.
Thank you so much, Nishank. Pleasure is all mine. Thank you for having me, and thank you for that introduction. It sounds a little bulky, but it is not, given the length and width of our profession. But yeah, yes,
Sir,
thank you so much.
it does not at all. Firstly, I don't think it sounds bulky, sir. The amount of I was just so in Khaitan, like you can just see and download sir CV. Generally, we sort of sit and prepare introductions, but I was just amazed to see the kind of deals that you've sort of worked on, sir. Before we delve into the technical part of the interview, before we start talking about arbitration in general, the different sort of aspects that have come up, especially with the arbitration and there is an amendment bill also in October that sort of surfaced for it invited public comments. We'll talk about the different areas. Sir, how exactly did Khaitan happen to you? Can we just get into a little bit of your journey, like how the journey started and where you are today?
Yeah, sure. So, in terms of my entry at Khaitan, that was pursuant to an internship, and the story behind internship is also very interesting. Back in the day when we were in college, internships, yeah, like today, were very difficult to get, right? And I was an average student, always in the middle ranks. So I had an internship fixed in Delhi with a law firm, but that somehow got cancelled. So I was in Delhi for my internship, and since that got cancelled, I was a little worried, and I did not want to go back. So with the help of one of the senior counsels who I met, who is right now one of the judges in the Honorable Supreme Court of India. I got lucky to get an internship at Khaitan. That was in my third year. And that internship went so well because most of the litigation folks were on leave because of the summer holidays. So I got to work with a very senior partner during my internship on very interesting deals. And that was in my third year, and I back to back got internship from third year, fourth year, fifth year. So I had like multiple rounds of internship with
Wow.
Khaitan. Perhaps, they also liked my work. I also liked the culture. So that is how, and then they ended up coming to our campus. There was a whole process of group discussion and personal interview basis, which a PPO was given.
Right.
Me, along with my batchmates, I think four of us were selected, and that is how I ended up at Khaitan.
Wow. Wow. Wonderful, sir. And sir, you said campus. Sir, which campus are we referring to?
So this is NLIU Bhopal.
Right. Right.
Uh,
Right. I
so yeah,
yeah.
yeah.
I didn't want to say out that loud, but yes, sir, is also from one of the top NLUs, sir. But like campus placements, you said right? PPO was given, interview was sort of conducted, and that is how the process is, and it's really wonderful that you got to also work on so many sort of, especially when you're saying that you got to work with a senior partner, and like when we are as students, like looking at third year, fourth year, or fifth year, especially, that excitement is there that I need to prove myself. I have to show like that I also hold merit. So one very important thing that also sort of I was thinking or what comes out is that you said that there was a process that is conducted, and that is generally how campus placements are done across India. Sir, like you said, you and four other students get selected, but in this entire process, and now that you are a partner, like what do you think you are looking at? And you can also answer it from a perspective of probably the younger Anchit, who sort of managed to get a job. So, what is it that a partner is especially looking at? And you can talk with respect to your area of or your subject matter as well. In terms of an not only just an associate, but when an intern sort of stands out, there are some interns who just sit, who are there and they got the internship and then they go. Their presence is not felt. How do you feel like with respect to interns and associates that they can leave a mark and move up the ladder in the profession?
Yeah. So see, in terms of what we look for, or what when I was young, I had focused on while getting a job or converting an internship into a job, or at the least leaving a good impression during the internship, is number one. You cannot compromise with the basics of law, right?
Right,
So that is non-negotiable, and it is not like that you are expected to be an expert while you are interning, but at your level, whatever level that you are, so for example, third year, fourth year, whatever subjects you have read, you cannot go wrong on basics. Maybe a little nuanced topics where the law itself is a little gray. There are
right,
judgments on both sides. It's okay. But basics, like for example, basics of contract law, like what is consideration, right?
right,
What are void contracts? What are voidable contracts? You need to have solid answers prepared for these basic questions, like what is specific relief?
right,
What are the recent amendments in specific relief? These basics will not change irrespective of how the law is developing. So that
right,
has to be there. So whenever I am interacting with any intern or a young student, the first thing that perhaps I tend to see is how clear the person is on the basics.
okay,
Right. The second things which generally stand out is, for me personally, is how humble and flexible the person is.
okay,
Right.
okay,
Because this profession requires you to perhaps change as a person a bit, right? So it's very important. Why I'm saying this, because that even the best of lawyers who have like 30, 35, 50 years of experience, it happens that when they are standing in a court of law, they might be arguing the point for the very first time, right? A
right,
particular interpretation. So even when you see judgments of Supreme Court by five judges, they
right,
are upturned by seven judges. That means there
absolutely,
is no certainty.
yeah, yeah,
Right. So you have to be a little tentative in your approach. So it's a little bit of concern for me when someone is taking a very strict position in
right,
law.
okay,
It has to be a little tentative, And you know what is the beauty of being tentative is that it gives you an opportunity to weigh on both sides, right?
Right.
You say that, A point, bucket A is this much, bucket B is this much, but on balance, I feel this is the position.
Better.
So
Yeah.
that nuanced approach, little bit, it stands out for me. For whoever does that, even if it is wrong side of the law, but I know that the person is thinking and has
Right.
made up third is a dedication.
Yeah. Yeah, you just broke off for us a little bit. Yeah, you were talking about yeah, it's absolutely all right now. I can hear you. But you were
Yeah.
saying essentially, yeah, please go on about how you were saying that the balance of the position is what matters to you more instead of, this one strict answer. Yeah.
Yeah, so it's actually refreshing to have that kind of approach
Okay.
from a young lawyer who is, thinking on both sides and,
Right.
giving a very nuanced answer. It's
Right.
very, very refreshing, and as whatever it gives you also points to think that, person is actually, weighing it out. The third is, of course, dedication, because in the initial years, with whole this debate going of 90 hours, 70 hours.
Yes. Yes, sir.
Yeah, it's crazy in law, right?
Right, right,
Uh,
right.
so yeah, dedication has to be there. The life can go a little wonky in the initial years. Work-life balance can be a little tilted more towards work, but yeah, it helps. And then as a person, it also helps the individual to grow.
Right, right, right. No, in the initial years, I had one of the partners come in from JC. He said, I don't think you should look for work-life balance, rather look for work-life harmony and harmonize your life accordingly as per your work, I guess, at
Yeah.
least for the starting years. And you, sir, absolutely right in terms of the dedication that needs to be put up. And sir, you have over a decade worth of experience. You've dealt with so many, I'm sure, high pressure environments, high pressure deals. So team coordination is something that a lot of students also struggle with, and it is something which is a reality of the practice. Like
Hmm.
I probably, let's say I can speak from the perspective of Jindal. You're given a lot of group projects, team projects. The idea is that you need to understand how to work in a team, because some people are just better as performing individually, but then when you're working in a team, you need to balance a lot of things out. So you over the years might have seen so much, and now that you are a partner, you must also have your own team, as one would say, like a bunch of associates, senior associates, and principal associates and whatnot working with you. So how do you feel that team management sort of ties in, especially at a tier one law firm, and how important it is for students to inculcate that skill from the onset?
It is very important, and while anyone is building a team, right, he would want a person to be part of the team when he's a team player. So that is also one of the key considerations while onboarding a person. That he and that ties in with what I said, a little bit of flexibility, right? Flexibility, not only your approach towards law, but also your approach towards other humans, right? There could be days where you have to take a little more if someone else is not well, right? You may have to cover for a person in a court proceeding where he or she is not able to make it.
Right,
So all those projects that you guys do at your university, practically, aligning with each other,
right,
they tend to be very helpful kind of an exercise, because team play is very, very important, especially in a litigation scenario. I'm sure also in corporate, but in a litigation scenario, why? Because if you're covering multiple forums, you are catering to multiple clients, you cannot deliver unless and until there is seamless coordination within the team members, right? So, as a matter, for an example, our internal practice is that, if the matter requires staffing of, say, one associate, we do staff two associates,
right,
just to have that backup ready, that as if there is any problem, the other one can step up and the client does not suffer at all.
right.
So that's a cost to us, right? Because but the cost is important to be borne by us in order to deliver efficient and smooth services to
Absolutely.
clients.
Absolutely.
And that depends on a lot of internal team matrix.
Right, right, right. No, and like the part about stepping up, because in a team, it's not like, I did so much work and this person did so much work, especially when you're sort of adhering to a client. The point is that the client should get the best, whatever relief or whatever he's looking for. possible, and then you just sort of cover up for each other. It's not really about who's outplaying one or the other person. Sir, one very, and like this interview is going to be a little different also, because we've talked a lot about aspirants. In fact, for the last 5 to 7 years since I've hosted this show, and then bringing it to the public since the last 3 or 4 years, we've talked especially just about aspirants, okay, because that is what the show was aimed for. If you are also sort of, and you also suggested this idea that Nishank, let's get a little bit technical also. Let's talk about subject areas, subject matters, which also sort of the students can benefit from. Sir, a very important sort of a debate that has been going on, and that is something that is given that you've worked on global deals. And if in fact we were to look at foreign institutions, for example, SIAC, for that matter, or the or even London for that matter, sir, a very huge contrast comes in between institutionalized arbitration and ad hoc arbitration. And with the sort of suggestions that are being brought in, and I think you can sort of comment better on this, you're the expert. Sir, what is the scope? Like, are we looking for a institutionalized arbitration? Like, can India become a hub for an institutionalized arbitration, given that centers in Bombay, Delhi, and now the Hyderabad IMC is also sort of there? uh, are we looking like in that direction, or is it still a far-fetched dream?
See, India, both in terms of statutory development and practice, is moving more and more towards institutional arbitration because that is the only, perhaps, way to get arbitration mess sorted, right? Ad hoc arbitration had its own challenges in terms of, the predictability of the whole process, the predictability of the fee aspect, because there was no schedule earlier on in the Arbitration Act, and it was little not so clear that how the process will play out.
Okay.
Now there is also an amendment proposed, right, in the
Right.
Arbitration Act, where it appears that we are completely going to move towards institutional arbitration.
Right.
Right. But I personally feel that even institutional arbitration as a concept is not the final solution to the arbitration issue, right? Because even if we move under an aegis of an institution, there will be same individuals, perhaps, who would be manning them, being appointed as arbitrators. So India is definitely going to be an hub of international arbitration. Why? Because the business is such, the economy is such, and the world situation is such that India cannot be, overlooked by any company investors, etc. Right? But we still have a very long way to go in terms of making the arbitration mechanism efficient. We still are a little lagging behind in terms of process, perhaps because of lack of training.
Okay.
Yes, and lawyers, arbitrators who have been part of international arbitrations, who have done arbitrations, for example, under ICC, SIAC, London, etc.
Yeah.
There is a stark difference on how they manage and conduct arbitration because they have been exposed to, a concept which is slightly more efficiently driven, right?
Okay. Okay.
So that is where we are headed. Slowly and steadily, we'll reach there
Right.
because the quality of lawyers and arbitrators in India is improving by the day. And if you look up the Section 11 judgments on appointment by High Court and Supreme Court,
Right.
both at both level courts are appointing young lawyers as arbitrators, which is a very good sign.
Yeah.
But the next step perhaps is to get some training, even for experienced folks, so that
Right.
we are able to completely tell the world that our system
Right.
is as transparent, as efficient, as predictable as any other institution in the world.
Right, right, right. No, absolutely, sir. And the fact that you even brought about these rules. the procedural rules like ICC, or for that matter, you said London LCIA. Sir, I sort of also wanted to like navigate these waters a little bit, if that's okay. Like essentially, how do the procedural rules, because we're talking about institutionalized arbitration, like LCIA, UN Citral, ICC, how do these sort of affect, how do these end up affecting your arbitration strategy, given that you can, like, it's not so sort of codified here in India? Does it sort of change the game for a tailor-made approach that you sort of take to arbitration, or is it not that much
I
of a
see it makes a difference because it's a different lay of the land, right?
right, right,
Uh, if you track the development of these rules, like for
okay,
example, SIAC, LCIA,
right,
uh, these rules are amended regularly in order to align with the business realities of the
right,
world,
right.
right? So, for example, as an example, if you see when SIAC was amended to include emergency
Arbitration,
arbitrators,
okay, yeah,
right? So people were actually facing a problem that it was taking a long time to constitute the arbitrator, to appoint the arbitrator.
right,
So a need was felt that, there should be some expedited process where if there is any urgent relief which is required, that should be built in the rules itself.
right,
The beauty of these institutes, which we are also as a country are adopting,
right,
is to quickly amend the rules to facilitate, business transactions,
right,
right?
right,
And when you talk about arbitration, it is on a global level, right?
right,
It is an international kind of a dispute resolution mechanism. So a party who is, say, for example, based in US or UK
right,
and is accustomed to a particular kind of efficiency,
right.
it becomes a very important point when they are investing any amount in India to know
Yeah,
that whether
yeah,
that efficiency will be replicated in India or
absolutely,
not.
absolutely.
Our courts are doing a stellar job in making the arbitration jurisprudence in that direction, making it pro arbitrator
Arbitration,
arbitration.
yeah,
Yes, but still, there can be a lot of confusion.
right,
So there are two stages, right? One is pre-arbitration when you are in the
yeah,
appointment zone or when you are in a Section 9 zone of interim
right.
relief.
Relief, yeah,
And then there is a post-arbitration zone. Once the
okay.
award is out, we are,
Enforcement and all that,
yes, yes.
yeah,
So I am dealing with a few cases in which enforcement has been pending for 5 years, right? So someone has got an interim award, and this is in the most sort of efficient court, which is the Delhi High Court,
right,
right? It is supposed to be, and it is one of the most efficient court. Even then, because of the change of roster, because of
right,
passovers, because of lawyers not being serious, etc.,
right,
etc. The matters keeps on lingering on. So we need to be on top of our game in both the limbs,
right,
in the pre-arbitration stage and post-arbitration. More so in post-arbitration because the party is not able to enjoy the fruits of the award.
right.
So it is very, very important that we are able to drive efficiency at both stages.
Right, right, right. Absolutely. Sir, I think the fact that, in fact, one of the seasons that we had hosted, and we had an entire summit based on the fact that we had brought in judges, we had brought in lawyers to understand and also sort of realize what the actual difference is in respect to these huge pendency of cases. Like you said, like even for enforcement, and we're talking about the Delhi High Court with all the due respect. I mean, it's a fantastic court compared to a lot of other courts in India. But then yeah, you're right in the sense that the problem sort of still persists in different ways, and the idea is not to sort of put a blame on any sort of I think part of the like system, whether it's the judiciary or the lawyers or anything for that matter. The point is that together I think we as a system somewhere are lacking, whether it's you talked about the different infrastructural challenges, the challenges in terms of the codified sort of versions of law, how we are making sort of amendments. One sort of very important aspect which I also feel is that the fact that they make changes according to the realities of the business world. They make changes according to the realities of how transactions are taking place in today's world, and that is something. It's like an upkeep game. You need to
Yeah.
sort of constantly be assessing the dynamics of it. Thank you so much for sort of beautifully also pointing that out, sir. You talked about a little bit about the pre sort of stage as well. Mediation, negotiation. In fact, a lot of competitions are for law students are running in India based on mediation competitions, wherein they're getting to learn about mediated settlement agreements, act as mediators. And do you feel that also what role, in fact, actually does pre-arbitration, mediation, or negotiation play in shaping an approach? Like as a client, if you're sort of looking forward to solving your disputes quickly, negotiation is more of an informal way rather than compared to mediation, and then obviously arbitration is the most formal aspect of the three. What sort of role do these pre-steps also sort of play before we sort of go into arbitration?
So they are very important steps, and they can actually cut down the controversy a lot if it is driven efficiently. We have seen matters get resolved during negotiations and mediation. It happens. Given that both parties are a little open,
Right,
and the mediator is able to bring them on a common place. It happens. It
right,
is not that it is completely, but sometimes what happens is, like, for example, in a PSU scenario, right, in India, you have written to them. Now they don't respond at times, right, at all.
right,
Now, even if there is an inbuilt mediation clause in the arbitration that you will have to first exhaust that particular remedy, and then only you can sort of go to arbitrate. How will you do that if the other party does not respond, right?
right, right,
So it has to be a two-way process, and
right,
the matured businesses, they understand that there's no gain in going for the dispute at all.
right,
Even as you say that even if you have to give up something, but if you're able to avoid the lengthy process of arbitration, it reflects your maturity, right?
right, right,
So people do benefit a lot from these kind of clauses
right.
in pre-arbitration scenario. And you will see specific rules which are framed by SIAC, which is
Okay,
like med, or which is like mediation, arbitration, mediation. First you mediate, then you arbitrate, then whatever is left, you again mediate.
right,
So people, as I said, people have developed rules according to the business realities, and they do encourage people to settle these kind of
right,
cases.
right, right, right. Absolutely, sir. Sir, one of the aspects that sort of also was coming into my mind, and also I've seen you like speak very heavily on this also across forums. In fact, I first saw you when I was, I think, in like 4 or 5 years back. I was just in my first year, and I was attending a public webinar that was there, and you sort of were talking about the different aspects of arbitration. I think 3 or 4 years it's been, at least as far as I remember, but I may be wrong. But sir, you have sort of, you are one of those people who's also worked with investigation agencies, right? You've worked with the CBI, you've actually dealt with matters. That would be a better way to sort of put it, related to the ED and all of those things. Sir, how do you sort of, and what impact, in fact, do these regulatory investigations, if any, do they have on arbitration proceedings? Do they sort of ever sort of tie in with arbitration proceedings, or have you just dealt with them in a litigation sort of a manner?
No, those are two independent work
Oh,
streams.
independent. Okay, okay,
Yes.
okay.
So on the investigation side, it's a different, completely, we are dealing with completely different kind of laws,
Right.
completely different kind of mechanics. Uh, there could be a potential scenario where there is an offshoot arbitration as well,
Okay.
because the law is that, both remedies are independent. But
Right.
if there is a pure allegation of corruption,
Right.
right, then it's a separate matter altogether.
Right.
And that is where CBI, ED, etc. come in.
Right.
So yes, I've been part of some interesting investigations, which requires a different kind of analysis and mindset.
Right.
Yeah, but the overlap, there's no
Okay,
apparent overlap.
okay. Yeah, yeah, yeah. No, but because it is sort of important to clear the air, because I don't think just because when things are collated together and it's written down, and even in the introduction I sort of wanted everybody also sort of to know that even in fact for different sort of matters, as we'll also sort of talk about in this litigation and arbitration can also sort of go like separate ways. It does not especially have to merge, especially in the fact that you're dealing with commercial sort of transaction. Sir, since we wanted to also deal with specific subject matters or important topics that we could also sort of bring in students could benefit. Sir, you talked a little bit about the interim relief and the situation. Can you just, in fact, comment on the concept or situation of emergency arbitration in India? Because after the Amazon case, that is sort of where we see sort of the landmark judgment. In fact, that is what is being taught in most of the schools as well. That is the first time we thought along the lines of, and you can obviously correct me if I'm wrong, along the lines of delving into emergency arbitration for that matter. Do you think the case for interim relief, like you said, and you're talking about of the fact that 5 years down the line, the enforcement of an interim relief award is still pending. What do you see in terms of the situation of emergency arbitration in India?
Right. So, just to clarify that though the matter that I referred to relates to a final award,
Okay,
which is
okay,
pending.
okay.
Uh, and in terms of your question on interim relief and the concept of emergency arbitration, it is becoming more and more important, right? Because in a scenario, so if you read any of these rules, institution rules like
Right,
SIAC, LCIA,
right,
they are flexible to adopt to the national or domestic legislation. For example, if you are having an SIAC arbitration,
right,
the SIAC will give you flexibility to approach Indian courts
right.
for any interim relief. The only
Okay.
exception to that is that if parties have voluntarily agreed that Indian courts will not have jurisdiction, right? If there is a written agreement to that effect, then Indian parties cannot come to Section 9 court.
Right.
Otherwise, the default position is that you can approach Section 9
Okay.
court.
Okay.
Now,
Okay.
interesting question that arises is that supposing, hypothetically speaking, if you are in international arbitration, you
Okay.
have both the options. You have option to go to an emergency arbitrator,
Right.
uh, and you have an option to parallelly or as an alternate come to the Section 9 court in India,
Right.
right? Or maybe Section 9 court in UK.
In
You have
UK.
the
Yeah.
court system in your aid, or
Right.
and you have the institution in your aid. Now
Right.
uh, now you have to make a choice as to which will be more effective,
Right.
right? Because if you come to Section 9 yeah, in front of a court,
Right.
the theory is or the law is that you can also seek injunctive relief against third parties,
Oh,
right?
okay.
Who
Okay.
are, yes, who are not signatory to the arbitration agreement,
Right.
but who have some nexus or who are acting through or under the main parties,
Oh,
right?
okay. Okay.
And the other benefit is that it's a direct court order, right?
Ah.
It is not like you are getting an interim
Right.
award kind of a situation when you are enforcing that in India.
Right.
Although the after the Amazon, even that has become easier,
Easier.
but
Yeah.
parties prefer a direct court order against the party and a third party
Right.
when the situation is such, right?
Right.
So
Right.
you
Right.
have to take a
Call.
judgment.
Yeah.
Yes. Now, supposing you are in a domain which is highly technical, like for
Okay.
example, if it's a mix of IP and contractual dispute,
Okay. Okay.
right? And you think that, it will take a little longer for an Indian judge to,
Sort of give
understand
the.
the
Yeah.
yes. But if you have an arbitrator who is an expert in that particular area and who
Right.
has given multiple such orders, right?
Right.
So then you might take a call that it's better to, take our chances before the institution. So
Right.
it depends on what kind of situation are you in. Again, like for example, if there is a jurisdiction clause in India,
Right.
uh, which is taking you to a court which you think might not be very open to giving such a relief ex parte,
Right.
right? Then you will shift to institution.
Right.
But if you are in a court which is, very, you've seen multiple cases of such reliefs, you will come to this particular, you will be, and then also then the question of cost is also important, right?
Right.
Because court will be a little less expensive as compared to going to an emergency arbitrator. So depending on these factors, nationality of the arbitrator, jurisdiction of the court, versus the subject matter in which you are dealing, etc., etc., you have to weigh all these options and then suggest a course to client. So yeah.
Right, right. No, absolutely, sir. You know that genie that sort of grants three wishes. I would sort of grant one of my wishes today, sir. Which would be listening to you more. I mean, thank you for sharing your insights so thoughtfully, and I think with such precision. You have this ability to tailor sort of complex concepts into clear and practical explanations. You know, the host inside me sort of steps away, and the student also sort of comes out, because I just felt like I was in an arbitration class. The way you were explaining, and sort of I wanted to follow up when you would have said that, but then you brought out the question yourself, and that's sort of the beauty of how you answer. It's also evident that your expertise is not just about knowing the law. You understand how its application is done in a way that it adds immense value to your clients and the legal community. The real sort of difference that you showed, like for example, if you are in a court abroad and you can just get the court to sort of act on it, that is more sort of a, like, it weighs heavily more in your favor, compared to, wherein if you see in, like for example, in India, you feel that the judge might take a longer sort of a process in understanding the dispute, and it'll take sort of a longer time. Then you just go to an arbitrator if they have more expertise. And the fact that you weigh in all these conditions also so beautifully, and I think that your answers sort of reflect a deep understanding and experience. So, and that makes the discussion for me also very enlightening and engaging. So, thank you so much. I just wanted to take a moment to sort of
No, no.
put it across. And sir, let's just also talk about arbitration clauses. Like that is sort of the essence. When you see it, all these things are the essence of arbitration. I mean, these are sort of very critical concepts that we are talking about. So you have drafted so many arbitration clauses. Somebody who starts out in the profession might have to draft an arbitration clause. Do you see any common mistakes people make while drafting an arbitration clause? Do you think that there is a certain way wherein if you ensure like these three, four or five factors, you can sort of foolproof your arbitration clause to begin with?
In terms of arbitration clauses, again, there are two periods, right, which we have to deal with. One are those old agreements, right, in which the disputes is occurring now. So, for example, if an agreement was executed 10 years back, the arbitration clause was still an art, right?
Right,
Right
right,
now, the arbitration clause is a science. Why do I say that? Because as I said that these institutions, they constantly debate each and every minute detail of the arbitration clause.
okay,
So you don't have to reinvent the wheel and you can simply adopt an SIAC or ICC
right,
arbitration clause because that is very well thought out.
right, right,
Where your expertise come in is to tweak that to protect your client's interests better. So
right,
again, for example, if there are 10 elements in a SIAC clause, like a place, like a seat, like a venue, like a jurisdiction, like qualification of the arbitrator, like the timeline, express
right,
exclusions, express inclusions, you have to see for your client as to how would you like to tweak it. more
right,
more and more now arbitration clauses. Earlier it used to be called as a midnight clause where the corporate lawyers will just tell you at the last moment that this is what we are signing, let us know
right,
if it is fine. But now more and more arbitration clauses are very nuancedly drafted,
right,
uh, because corporates are realizing that once they are in a dispute scenario,
right.
uh, even a small change in
Sort
the
of, yeah,
arbitration clause
yeah,
could result in a drastic change in the outcome.
right,
Right. And once you are given, and see, it also depends on how much bargaining power you have, right? If you are
right,
acting for a big multinational
right, right, right,
corporation, you will be able to sort of, put in language to protect your interest. But if you're on
right,
the other side, right,
right,
you have to be very smart about it and
right,
uh, benefit from the default positions in law, right? So,
right,
for example,
right,
as I told you, the default position under the 96 Act is that Section 9 will continue to apply to international arbitration unless it is expressly excluded, right?
Right,
So
right,
now just again as an example, if you want to have Indian courts jurisdiction as a party,
right.
uh, you will prefer, being silent on that, right? Because
Okay,
law is anyway default position is in your favor,
right,
right? You will not want to, make a lot of noise about it that, I want interim protection. You please, include a court, right? So you will be quiet about it because the default position is in your favor, right? Yeah, and a few elements which are there, Nishant, which are important in the arbitration clause. And as I said, it is science.
right,
It is not an art anymore. You can
right,
just pick these standard clauses and go with it.
right, right, right. Fair enough, fair enough. Sir, also like thank you so much for answering that. Like in terms of the common mistakes also that the lawyers make, and probably you can address it as a part of my next question also. Like in
See,
terms of not, yeah, 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 please.
common mistakes is which parties do is not thinking through, right?
Right,
They
right.
copy the previous clause from the previous agreement.
Don't make it, yeah.
Yes, which was completely in a complete different context.
Context.
But if
Yes.
you apply your mind a little bit,
You will be able to.
yes.
Perfect, perfect, perfect. No, 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 that makes a lot of sense. The fact that you're talking about customizing each also sort of clause to the specific sort of dispute contract or XYZ, whatever thing you're dealing with, sort of sums up how you can sort of also avoid the mistakes in this area and the standard sort of clauses that they have also drafted. Like you said, it's a science and no more an art. Sir, but let's just also talk about a little bit of your deals, and also this will be more of an umbrella question. So you've worked on so many matters, and just talking about arbitration in general, if we not going into the diverse areas also you've sort of dealt with. So what is one sort of common skill that you think that you can bring in terms of even into the negotiation table, or the fact then when you're trying to understand a client's perspective and then maximize the relief that they're giving in, because at times like you deal with different sort of parties, you work with both. Like I see you've done work globally, you've worked with something that is completely related to a government based thing, like your work with respect to the I think the Israel military government, if military part of the government, if I'm not wrong. But then you've also worked with big corporates, and there is obviously a clear difference. Like you talked about the customized approach you need to sort of take in. What sort of skills do you inculcate to balance those two, and then understand how sort of a client works, and also how a situation works, because these are very two different sort of areas that we're talking about. One may be a very big MNC that you're dealing with. You dealt with, I think, the matters of Uber and Ola. You were there. That is also again, it becomes very different in terms of the kind of industry that you're dealing with. So you're dealing with different sort of industries, but at the same time you have this one common thing that's going on around, let's say, arbitration, or that one sort of dispute mechanism that you're undertaking. How do you also balance these things out in that context?
Yeah, so for when you're dealing with a matter, there are few things which will apply across board,
Okay.
irrespective of whether you're dealing with an MNC, or dealing with a PSU, or dealing with an individual,
Right.
right? That is the number one thing is clarity on facts.
Okay.
uh,
Okay.
Whoever has mastered the facts
Right.
has won half of the battle, because at times what happens is even when the clients give us documents, they are not complete, right?
Right.
The client may think that a particular document is not important, but as a lawyer you need to have an absolute complete picture. So
Right.
in fact, that is one of the rules that we follow in our teams, is to have a complete grip on the facts, and this
Okay.
will apply across board,
Okay.
MNCs, PSUs, or individual.
Okay.
Once you have that, then, for example, if you're dealing in a sector which is still upcoming. So, for example, when we were advising Uber,
Right.
the motor vehicle rules, laws were still, being changed,
Okay.
because Uber as a category of
Right.
aggregator
Right.
was not fitting anywhere,
Right.
right?
Right.
The concept did not exist in law. So
Okay.
law was also catching up. In fact, in one
Okay.
of the orders passed by the Delhi High Court, the
Right.
court recorded that the law is still catching up. So we
Right.
cannot sort of hold Uber liable for ABC when the law is still not there.
Yeah. Yeah.
Right. So then you also little will deal into the policy aspect.
Right.
Now,
Right.
coming back to your question as to how do you tailor the approach in
Right.
terms of, so again, two broad buckets.
Right.
One is a sector bucket, right? Or
Okay.
a particular industry bucket. So, for
Okay.
example, if you are dealing with a client who is into construction,
Right.
as I said, arbitration clause is a science. Construction dispute is
Right.
also 90% science,
Okay.
right? There are books which will tell you how a construction schedule progresses, what are the technical aspect of each, delay which affects the overall recovery of the project,
Hmm.
how the staffing is done. So it's a complete different study,
Okay.
right? So
Okay.
that's so if you are dealing in that, we prefer to educate ourselves into the nuances of that particular industry,
Right.
right?
Right.
So you have to step back and assess on which territory you are in,
Right.
right? If
Right.
it's a construction dispute, you have to get back to that, understand the nuances. Now, if it's an emerging field, as I said,
Right.
Uber
Uber
back then,
case. Yeah.
then you have to draw a lot of international comparison and how the
Ah.
other
Okay.
countries have regulated,
Exactly. Exactly.
and the client also parallelly drives the policy thinking in the country, right?
Oh. Okay.
So all these companies like Uber, Ola, Blue
Yeah.
Smart, etc.,
Yeah.
they continuously liaise with the governments,
Okay.
which result into framing of laws, framing of rules,
Right. Right. Fair enough.
right? So then it's a mix of a policy, the existing law, and the future law, right?
Absolutely.
So that is how you, and once
Absolutely.
you,
Yeah.
yeah,
Yeah. Yeah. Please go on.
and the third bucket is your run-of-the-mill matters like a contractual dispute.
Right. Right.
So those are standard this thing. What weighs in that are facts because law is more
Yeah.
or
Yeah.
less established.
About yeah, about facts are very important. No, and the one who masters the facts, like you said, 50% of the game is won there. And it's also very important to sort of highlight one very important aspect that you mentioned is sometimes clients feel that this a particular document is not relevant, and but that does not, because they are not the ones who are dealing with law every day. So that does not define like the scope of documents that you should be also sort of asking them, because when you understand facts, when you understand sort of how the process takes place, different things that might be not accounted for by a client would still weigh in your own mind, and you'd be like, maybe this at this stage can be very important. I should actually have a I should actually have a due diligence done on this aspect of the thing. And probably I mean that is also something that all lawyers can also sort of take in, to not just rely on their clients for that matter for all the documents that they are sharing on board, but also understanding that there might be different sort of aspects to what can be brought about, especially when you're dealing with such complex cases of operating across jurisdictions. Sir, one very like this thing that you talked about territory, we are obviously talking about the industry that we're dealing with, but you're also dealing with international clients so many times, and sir, obviously you feel and you understand as well. I think there is a lot of disparity in cross jurisdiction disputes. Like, for example, and I mean, you can explain it better in terms of the clients that you have dealt with. The jurisdiction of, let's say, USA, UK, or Israel for that matter, all these things have their own laws. And when you're dealing with multiple parties within a cross jurisdiction sort of a claim, that becomes very difficult for a lot of lawyers who are sort of, well versed. Let's say you're well versed with the Indian Arbitration and Conciliation Act, but then you're dealing with someone who's operating in a very different jurisdiction. How should be in terms of, I'm talking about territory in terms of the country itself. What should
Yeah.
be your approach to sort of balancing those cross jurisdictional issues that can arise, and the different positions of law that you sort of need to weigh in and weigh out?
Yeah, yeah. So the thing is that so the default position is that as Indian lawyers, you're only allowed to advise on Indian laws,
Okay, okay, okay,
right? So that is point number one.
Okay.
Having said that, when you're dealing with an international client, it is always helpful to understand where they are coming from,
Okay.
right? They are, for example, baffled at the number of cases which are listed in a day before an Indian court,
Right.
right? So they are also sometimes at loss, especially in an international arbitration. So, for example, our Contracts Act
Right.
is quite similar to that of UK,
UK. Yeah.
uh,
Yeah.
right? But there are certain concepts within our contract law which are dealt differently in UK
Okay.
as compared to how we deal it in India.
Okay.
Now, supposing you are in an arbitration with a arbitrator who is from UK
Right.
and who is opining on Indian law,
Right.
right? He will deal with that concept in the manner he has been trained it, right?
Right. Right. Absolutely agree.
Now, therefore, those people who have dual qualifications,
Right.
like Indian lawyers who are UK qualified,
Right.
or those lawyers who have taken the pains to even analyze the position
Right.
abroad,
Right.
they are able to get into the minds of the arbitrator. They know
Okay.
what he is thinking.
Right.
They will be able to know what evidence will turn the position in their favor.
Right.
They will know exactly how their mind is trained,
Right. 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 Absolutely.
right?
Yeah.
So that is what makes a difference. So one of the arbitrations that we were doing, we were
Uh,
led by a senior counsel who
okay.
was also English qualified barrister.
Okay. Okay.
Uh, and I personally learned it from him, that how he thinks that the arbitrator might be thinking on a particular point.
Right.
He told us a particular way to present evidence. He told us
Right.
particular questions to be asked to witness so as to convince the chair arbitrator. The other two
Right.
were Indian guys. They understood, and they were actually quite disturbed while the process was going on because they thought
Right.
it's a normal thing. But we had to convince the main arbitrator as well, right? The chair arbitrator. And therefore we
Right.
had to take a little nuanced route with the help of that particular senior counsel who told us, who educated us on, why a particular direction is being taken. So it's a teamwork. It's always learning.
Right.
Now that particular learning is always at the back of our minds when we are dealing with a person who is trained in a different jurisdiction.
Right.
Uh, I'm still not, I have not done any LLMs, etc. But people who have
Okay.
done LLMs, they have far more nuanced understanding of a person who is coming from a different jurisdiction. So that
Right.
is where, your LLM actually helps also,
Okay.
not just in law, but to understand where the other person is coming from.
Right. 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 Absolutely. No, sir. In talking to you about arbitration, it feels like attending a master class. The syllabus adjusts itself mid-lecture, and then obviously you tailor all the answers. And it's absolute brilliance. I'm enjoying this session thoroughly. But also, we'll also come to the closing aspects of it. Now we'll move towards closing the session. Given the paucity of time, sir. In general, also now we've talked about the different technical aspects, but there are a lot of because at the end of the day, I sort of aim to help the aspirants with these shows. Sir, in general, also, like when you're dealing with, now I'm going to ask this question from the perspective of, making up into the ladder when you're dealing with a top tier law firm like Khaitan, for that matter, or sir, for any sort of firms. Also, sir, have you like always been associated to Khaitan? Has Khaitan been your home for
Yeah,
over
yeah,
the, oh, absolutely. Okay, wonderful. Because we've had people who sort of shifted firms and now are in sort of different firms. So you've grown within the sort of the same vertical also. Now, an associate, a lot of people feel that entry point is the barrier. And it is true for a lot of people who have come from not so privileged backgrounds. In fact, they do not have neither the networks. Some of them are just not willing to work hard, also. There are people like that. But then a lot of people who are genuinely trying to put in all the effort. But then the kind of college, the kind of financial background they're coming from, all these things also matter a lot. Sir, once also they step in, like it's not just about becoming the associate, because there are years of work that have gone by into you becoming a partner today. Sir, what is it that sort of helps a person grow? In the sense that you obviously all have to know your background well, you have to know your basics well, but then life moves beyond basics also. You need to be, you are attending high pressure meetings, you're attending to MNCs, global clients, across board, across forums. From an associate to a partner within your own journey itself, how different does it become, and like what is that ladder that you need to sort of constantly self improve, or it just happens over the years, and is it something like that? I mean, you could comment better
No,
on. Yeah.
it just does not happen over the years.
Yeah.
It takes planning, it takes execution,
Right.
and the dynamics has completely changed.
Right.
Completely changed.
Right.
So basics, number one, of course, very important.
Right.
Uh, what element will now take precedence, which is also a point where you can consider parallels from international law firms,
Right.
uh, is the ability to develop business from the day go,
Right. Right.
right? Right. So, we as Indian lawyers, as Indian students, are not given, due training during our college after
Right.
that. And there are so many courses which are now happening, etc. People
Yeah.
are speaking about it.
Right.
Uh, so that is very, very important aspect, which will play a very important role in the journey,
Right.
either within the firm or within different firms or different
Right.
setups, MNCs, etc., etc. Right? That's the other aspect which plays an important role is uh, value creation, right?
Right. Right.
What value are you creating both for your client
Client and your
uh,
firm.
and your firm, right?
Absolutely.
It value creation sounds like a very simple concept, but
Right. Right.
it is like an iceberg, right? It
Absolutely.
takes a lot of this thing and yeah, what value basically you
Right.
creating, what differentiating
Right.
points,
Right. Right.
right?
Absolutely.
So yeah,
Yeah.
so yeah.
No, if you wanted to say something more, please. Like
No,
otherwise.
no, I'm saying that yeah, those are apart from the
Yeah.
usual
Yeah.
stuff of
Usual stuff.
working hard.
Right,
Yeah,
right, right. No, absolutely, sir. That's very well put. And the fact that I sort of, in the end, put the fact that, it just does not happen over years. You know of people who take much, much longer time, given that you're just in a firm, if you just are slogging for the sake of putting in the hours without the output, without the efficiency, and without the results that you are talking about, you're not gonna make it up the ladder that quick as well. And more importantly, it's not just about making up the ladder. I think when you do not understand the kind of work that you're doing, the kind of efficiency, or as one would say, the amount of business also, in the sense
yeah,
like you talked about, you're not growing from within as well. Forget about the salary and forget about the firm and whatnot, and all these things are a later factor within yourself. You, for someone who knows, that I can handle clients, I know that I have worked on this, I know that I can improve in these areas, he's much better positioned. Sooner or later he's to find success, as one would want to place it in their own different ways, but they would sort of, because they understand the matters, they understand, and the skill is that they sort of are working in an environment when they're trying to improve upon the aspects that they sort of need to work upon, but at the same time need to cater to the different sort of aspects of the clients and also the firm that they're
yeah.
working for. So the
Firm is also
balance,
your
yeah.
client in a way. You know,
Right.
firm is also your client.
Right.
You are an earner for the firm, so
Right. Right.
yeah,
No, that's such a different also way of seeing it, right? Because
yeah,
you actually, it's true. That's also a fact, sir. One very, I think this will be one of my last questions to you, for the episode today. And thank you so much for wonderfully answering all the questions, sir. One very important aspect is that a lot of students just want to do arbitration, but that is not dispute resolution as a practice as a whole, because dispute resolution is much more than that. It involves litigation. I see you working on so many different aspects. In fact, you, like you said, there are, when you talked about, for that matter, CBI, or you talked about ED, you said that, that this is something that is a little different, Nisha, in the sense that what I do in a corporate setting, or what I do with these regulatory sort of agencies, is way different, right? For somebody who's trying to work in disputes, what apart from the Arbitration Act should they be looking for? Contracts, we understood. We understand that there is an Arbitration and Conciliation Act. But people also often sort of tend to ignore the fact that you talked about how negotiation also sort of weighs in at times, mediation weighs in. But to be a complete professional, in the sense that somebody who says that I practice dispute resolution, what are the other aspects apart from the basic contracts and arbitration that you sort of need to master and then become a professional?
See, arbitration is a process,
Right,
right?
right,
It has some substantive elements, but by and large, it's a procedural law, right? So
right,
arbitration is only a vehicle, a mode of dispute resolution, but in arbitration also you end up interpreting the substantial laws, like specifically like the Indian Contract Act, Trust Act, right? So that is number one, that you have to be clear. Arbitration sounds fancy, and that is actually one of the shortcomings, I would say, that we are entangled so much in the process itself, right? So if you slightly zoom out, half
right.
of the litigation in arbitration earlier was on the question of how the arbitrator is to be appointed, right?
Okay, okay.
Recently, in a five judges Supreme Court has clarified after so many years that, A, B, C are the yardsticks of appointing. So we are still,
Right,
which is just a procedural aspect,
right,
right, on how
right,
the arbitrator has to be appointed,
right,
right? So that's number one. Number two, in terms of a well-rounded dispute resolution lawyer,
right,
it's very important, and sometimes Lux also plays an important role, that you deal with a variety of matters. Like you
right,
deal with consumer matters. If you get an opportunity to do a little bit of tax, because philosophically there is a thread which is running across the statutes. There is always an intent, there is always a mischief which a statute is trying to solve. And the idea is to hone your skills in understanding that common thread. So, for example, even when you are doing a dispute in relation to, say, for intellectual property, right, a trademarks dispute, you will understand that why, a particular clause or why a particular section in the statute is given the way it is, right? So once you are able to grab that granular sort of detail of the problem, now then you are able to holistically advise the client, right? And that is what separates you. And no one is a complete 100% dispute resolution lawyer, because even the best of lawyers have not dealt with all the aspects of dispute resolution, right? But the
right,
stalwarts that we have today, they have
right,
dealt and they have understood the aspects which they have, argued. So, for example, lawyers like Mr. Rodki, Mr. Sibbal, Mr. Salve, why are they so successful? They are so successful because of the breadth of their practice, because they have dealt
right,
with so many situations, and
right,
they have understood the judges' reaction so well that they are able to almost predict the
right,
outcome, right?
right,
So, as a young lawyer, more and more reading of the aspects of the laws which you're not directly dealing in. But the tricky situation is that as a human, at least I feel that handicap when I am reading a law on which I'm not working. My mind does not, grasp the nuances so well as compared to when I'm advising a client on a particular new sort of. Then I'm able to, deep dive, connect, etc., etc. But those who are able to understand laws without, actually working on it at the present moment are it's a good practice to do.
right, right, right. No, and sir, I feel also beyond the technicalities, the fact that you managed to sort of shed light on the evolving role of these both commercial and corporate, and also of obviously litigation based aspects. I think to my viewers also it offers a more refreshing perspective, and I feel on my show very few have been able to match that. Sir, it's been an absolute privilege to learn from you, and I wish, like, if I sort of wanted to, I would just end up asking you questions all day, because there are so many aspects. I don't think in any one interview. In fact, I could just take a series of sessions just trying to understand these different sort of aspects from you. But I don't think it's possible to capture every aspect of it in one interview. No, it's like I was saying, it's been a privilege to learn from you. I sort of truly admire also the passion and expertise that you bring to the table. And as one would have it, like a wise man can sort of learn more from any sort of a foolish question than a fool can learn from a wise answer. And but in your case, your answers are like nothing short of wisdom personified. I feel it was very, the way you've spoken is very layered, insightful, and also sort of immensely enriching for me. So, like you say, I think your answers are definitely an art, and you're constantly applying science to it, and that was sort of sums up this episode on my behalf. Thank you so much. We'll just take one last message from you for all the aspirants, for people across India, especially legal aspirants, is what we sort of target for this show. And any comments on the show itself would also be appreciated. I would just, like I say, highlight that part, and then whatever praise you give to the show, we just put it in the front. Just kidding about that. But yeah, no, please, one last final message, and we'll end the show on that note.
No, I wanted to take this moment to thank you for those kind words. I honestly feel that I do not sort of fit into those praises at all. Still learning, still growing. But yeah, it's an privilege to talk, to share whatever little insights that we have. And the show is a great platform because, as I said in one of my previous interviews, the internet is actually a place to learn and putting out good content for people, making it accessible, can actually change their lives.
Right.
Because I am myself benefiting a lot from these podcasts. I
Mm.
just put them when I'm driving. It has completely changed the way I'm thinking, right? Those
Right.
special new podcasts like of
Right.
Nitin Kamath and
Yeah.
the other ones, they are like amazing. And this is the power of internet. We should all harness it. The one message that I want to perhaps end with is that in the world, in the future, the two skill sets. One is an active skill set of developing new skills, will be equally important to protect yourselves from distraction,
Right.
because social media and the kind of addiction that we folks are having at our levels as human race, it can be equally mind numbing
Right.
as it can be mind enriching.
Right.
So please take conscious call to avoid the avoidable stuff
Right.
and focus on good content, keep on learning,
Right.
and yes, be the best version of yourselves every day. Yeah.
No, thank you so much. Thank you so much for those lines also. I feel you're absolutely befitting of whatever we have said on the show tonight. In fact, for people who do not know, you can follow Sir on LinkedIn. His one-liners are all wit and precision. So he sort of manages to pack in humor, insight, and also, like I keep on saying, like he delivers. He manages to deliver every time he's sort of writing. I think you've perfected the art of delivering value with style, sir. Something you were talking about, but it happens a lot on your LinkedIn posts. I follow. You just make a one liner or a quick comment on a very serious matter that's going on, and then the take is obviously at times also very humorous. So thank you so much. And yeah, that would be the end of the show for us today. So were you trying to say something, or
No,
should?
no, go on,
Perfect.
good.
All right, all right. Thank you so much for joining in today. The show will be out in a few days from the day we are recording it, and you guys have been also a lovely audience who've been, whoever is sort of been chiming in, sharing. I hope you guys are benefiting. And thank you so much once again from the entire team of Open Floor with Nishank to Mr. Anchit Oswal, partner of Khaitan Co. We're signing off for the show for today on these grounds. Thank you so much, sir, for joining us
Thank
today.
you. Thank you.